Major Supreme Court ruling.
Major ruling involving the Second Amendment.
Supreme Court has just issued a major ruling.
It's a case that legal experts will be watching closely when it likely heads before the justices.
The ground just shifted under American gun law. 10 landmark court rulings have dropped in the last 60 days. What used to send ordinary citizens to prison for a decade is now protected constitutional activity. Law number 5 alone is reversing millions of firearm confiscations right now. And if you own a pistol brace, you need to know what changed this week. These decisions are rewriting Second Amendment jurisprudence faster than the media can keep up. And ignorance of these changes could cost you your freedom or your firearms. Disclaimer. This content is educational analysis, not legal advice. Consult qualified legal counsel for your specific situation before taking action on any legal matter. Ruling 10. The Baird Bomb, Open Carry Restored. January 2nd, 2026. The Ninth Circuit Court just detonated what gun rights advocates are calling the Baird Bomb, and the blast is ripping straight through California's entire carry framework. In Baird versus Veblen, the court didn't just strike down a single regulation. They demolished the foundational principle that governed California gun law for over 4 decades. Here's what actually happened. California maintained 2 parallel bans. No open carry in counties with populations over 200,000, and no concealed carry unless you could prove good cause to the satisfaction of a government bureaucrat. The result? Unless you were wealthy, politically connected, or could convince a sheriff you faced danger beyond what ordinary citizens face, you had zero legal way to carry a firearm for self-defense in public. The Ninth Circuit looked at that scheme and said something revolutionary. States cannot ban both methods of carry simultaneously. If you restrict concealed carry, open carry must remain available. If you ban open carry, concealed carry must be accessible without arbitrary hoops. California's system of granting police chiefs and sheriffs total discretion over who gets constitutional rights just died in federal court. And this isn't just about California. This precedent applies across the entire Ninth Circuit. That includes Alaska, Arizona, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington. Any jurisdiction playing games by making both carry methods effectively impossible now faces immediate constitutional challenge. The court applied the Bruen standard without mercy. The right to carry firearms in public for self-defense requires states to provide at least one realistic avenue to exercise that right. Ruling 9, the death of the waiting period. They call it a cooling off period. Here's what it actually means. If someone breaks into your house tonight and you don't already own a firearm, the government says you'll just have to wait 7 days before you can protect yourself. New Mexico thought that logic would survive constitutional scrutiny. The 10th Circuit disagreed. In Ortega versus Gisham, decided late 2025, the court examined New Mexico's mandatory 7-day waiting period, and it failed every test under the Bruen standard. The state's entire justification rested on preventing impulsive violence, the theory that delay reduces suicides and crimes of passion. The court demanded historical evidence showing founding-era Americans accepted similar restrictions. New Mexico produced nothing. Here's the part gun control advocates never want to address. Waiting periods only burden law-abiding citizens with legitimate self-defense needs. Criminals don't wait. Someone who just received credible death threats from an ex-partner can't wait. Someone whose business was targeted by organized theft rings can't wait. The court's language was blunt. Delayed rights are denied rights. Imagine telling someone they have freedom of speech, but only after a 7-day waiting period before publishing anything. The absurdity is obvious. This ruling doesn't stop with New Mexico. California's 10-day wait, Hawaii's 14 days, Rhode Island's 7 days, Illinois 72 hours. Every one of them now faces serious constitutional vulnerability. Gun rights organizations are already filing challenges. States wanting waiting periods must prove historical tradition, and that evidence does not exist. Ruling 8, marijuana users and the Second Amendment. This case represents one of the most significant conflicts between federal drug policy and constitutional rights in American history. United States versus him originated in the Fifth Circuit and is now sitting before the Supreme Court. But the Fifth Circuit's ruling already created binding precedent across Texas, Louisiana, and Mississippi. Federal law, Title 18, United States Code, Section 922, subsection G, paragraph 3, makes it a felony for any unlawful user of controlled substances to possess firearms. Penalty? Up to 10 years in federal prison. After Bruen, that changed. The Fifth Circuit applied historical analysis and found zero founding-era precedent for stripping gun rights based on substance use without dangerousness. The court noted something critical. In states where cannabis is legal, millions of Americans use it without criminal behavior. Teachers, engineers, nurses, accountants, people who treat cannabis the same way others treat a glass of wine. The government's position requires believing someone can be law-abiding enough to live freely in society but too dangerous to possess firearms without any individualized assessment. The court rejected that entirely. This logic applies far beyond marijuana. It applies to prescription medications classified as controlled substances. The government must now prove individual dangerousness, not checkboxes. Ruling 7. Engaged in the business. Shut down. October 2025. Butler versus ATF hit like a tactical nuke. The ATF attempted to redefine who must obtain a federal firearms license. Their claim? Anyone selling even one firearm for profit needed an FFL. That would bury ordinary collectors under fees, inspections, and compliance. For decades, federal law distinguished commercial dealers from private individuals selling from personal collections. The ATF tried to erase that distinction. The court said no. Congress meant regular, sustained commercial activity, not selling 3 guns from a collection twice a year. The ruling protects millions of gun owners who participate in the secondary market. Selling a handgun to fund another purchase? Lawful. Trading with collectors? Lawful. Thinning a collection? Still lawful. The ATF's interpretation would have turned millions of Americans into accidental felons. That ended here. Ruling 6. The pistol brace. Surrender. Late 2025, the ATF conceded defeat after losing in the 8th Circuit. Their attempt to reclassify brace-equipped pistols as short-barreled rifles collapsed. Pistol braces were developed for disabled shooters. Approved in writing by the ATF. 10 to 40 million sold. Then the ATF reversed course. Overnight, law-abiding citizens faced registration, $200 tax stamps, destruction, or felony charges. The court ruled this violated due process. The surrender means those pistols are legal again. No registration, no tax stamps, no destruction. One of the largest gun confiscation reversals in U.S. history. Quick pause. If you're getting value here, tap like and hit subscribe. It helps us reach more folks who need this information. Ruling 5. Nonviolent felon restoration. Range versus Attorney General changes everything. The government must now prove actual dangerousness, not just point to a felony label. Range involved food stamp fraud, nonviolent, probation, fine, lifetime loss of Second Amendment rights. The Third Circuit said no. Founding-era history supports disarming dangerous individuals, not blanket bans on nonviolent offenses. This affects roughly 20 million Americans. White-collar crimes, regulatory violations, tax offenses. Rights restoration is now happening nationwide. Individualized review is the new standard. Ruling 4. Ammo background, check strike down. Road versus Bont. The Ninth Circuit said it best. Protecting gun rights while banning ammunition is like protecting free speech while banning ink and paper. California required a background check for every ammo purchase. Millions of denials over clerical errors. The court recognized reality. A firearm without ammunition is useless. Ammo restrictions are gun bans by another name. Online sales are protected. Bulk purchases are protected. Practice is protected. Ruling 3. Sensitive Places Showdown. Antoniak versus James and Wolford versus Lopez. States tried banning carry everywhere people go. Parks, transit, restaurants, private property by default. Courts said no. Sensitive places must be historically justified. Culture doesn't override the Constitution. The Second Amendment applies in Hawaii the same way it applies in Texas. Ruling 2. Assault weapon common use test. Miller versus Bont and Barnett versus Rowell. AR-15 rifles number 20 to 30 million. That is common use. Courts are rejecting feature-based bans as cosmetic nonsense. Popularity does not justify prohibition. Ruling 1, the end of zero tolerance for dealers. ATF Administrative Order 5370.1 Hotel. Zero tolerance is over. No more license revocation for typos. No more business destruction over clerical errors. FFL applications are up 89% in 2 months. 60-day maximum processing. Delay tactics are gone. Final thoughts. These 10 rulings represent the most significant expansion of Second Amendment protections in modern history. The courts did their part. Now it's on us to know these rights and assert them. Which ruling affects you most? Drop your thoughts in the comments and subscribe to the channel so you don't miss what comes next, because this story is far from over.